Good afternoon, everyone, or I guess morning if you are east of Central Mountain Time. My name is Erica Hollar, and today we are going to be talking about FCRA and specifically some key points for employers and what they should know about FCRA. Again, my name is Erica Hollar. I'm a senior attorney at McMurray & Schuster. Like we always do, here's our legal disclaimer, and this is just a reminder that the information and materials presented today are for information purposes only. We are not engaging in any sort of attorney-client relationship, and that every situation factually does differ. So if you do have issues, we would encourage you to engage your counsel. Also, this webinar will be recorded and will be available on our website. So if you have a colleague that you think might like to see it or want to go back and take a look, it will be available there, I believe, at the end of the day. Also, we have a great deal of other webinars. So if you want to go take a look and peruse those and see if there's something else that might be applicable to your business practice or interesting to you, that would be wonderful. So I wanted to start with just a very high level overview of what FCRA is. FCRA is the Fair Credit Reporting Act. It is a federal piece of legislation, and it was enacted to promote the fairness and privacy of consumer information and files contained in credit reports as they relate to credit reporting agencies. And this act protects information collected by consumer reporting agencies such as credit bureaus, medical information companies, tenant screening services, and at a high level, it just regulates the way credit reporting agencies collect, access, use, and share data that they have access to by virtue of their role. So why does FCRA matter? As a legal practice, we're seeing it matter for a few reasons. First is obviously it impacts consumers, it impacts your customers, your clients. You want to do the right thing, you want to be compliant, but also in terms of litigation, we are seeing an upward trend in FCRA cases. And as we'll talk later, these sorts of cases have the potential to be filed as class action lawsuits, and that can have a real impact on your business, whether it's financially or stretching resources thin of those working in your organization. It can have a really big impact. So, there you see here in 2010, there were, I don't want to say only, but there were approximately 1,300 FCRA cases filed. And then when you go to 2020, there were 5,200 filed. So, over the past decade, we have seen a very big growth in this sort of legislation. So some of you might be familiar with TCPA lawsuits. Those also we saw peak around 2015, 2017. We were seeing a lot of those types of cases filed. What's interesting is since 2016, those sorts of cases have started on the downward trend, while comparatively, you see on the right there, the FCRA cases are just continuing to incline. And, we have some thoughts as to why that is. The TCPA, we thought, and for those of you who follow this area of the law, you are probably familiar with the Facebook decision that was just issued by the Supreme Court last month, I believe. I think it was April 1st. And, there was a lot of uncertainty on what a auto dialer was and what it constituted, the definition of that. So there was a lot of uncertainty as it relates to that TCPA area of the law, whereas FCRA is pretty straightforward. It's got very clear obligations outlined. It's kind of like a, you either do it or you don't. And so, we thought that maybe these class action attorneys were looking for an area of the law that was a little more settled. FCRA has been around for over 30 years. It was enacted in 1970, so it's not new legislation by any means. So, maybe they were looking for something a little more settled to start using as an avenue to file these class actions. Also, things have changed over the last decade in terms of access to credit monitoring, credit repair companies. All of that is so much more accessible for consumers, and as we'll talk about now next, potential employees or those applicants who are applying to your company. You have organizations like Credit Karma, where a consumer can get on and access their credit report for free, or FICO scores are available in the credit card statement. So there's just a lot more access to those sorts of monitoring and information that makes it much easier for consumers to know if there is or is not something wrong with their credit report. So in terms of your company complying with FCRA, the most important thing that we could recommend is make sure you have your internal policies and procedures buttoned up. Like I said, FCRA is pretty, I don't want to say straightforward, but it lays out very clearly certain obligations, and the FTC has published many guides on how to comply with FCRA. So we would encourage you to make sure that you have policies and procedures drafted that govern and cover all of those requirements that are in the statute. Not only should you draft those policies and procedures, but it's important that you audit on those, you continue to keep them up to date. As a general rule, a yearly review of those sorts of policies and procedures is good. It's not something you want to just draft and then put in the drawer and never look at again until there's a regulator knocking on your door asking, or a lawsuit saying, what's your procedures relating to FCRA? The next thing is accurate reporting to bureaus. So anytime if you are doing reporting, make sure it's accurate. It's very as simple as that, but you would be surprised to know how much it gets missed. And a lot of times it's a lot of data, it's just human error. And so that goes to the third point is, if you do come across an error, make sure that the errors are corrected as quickly as you can. Make sure you're addressing any sort of investigation, inquiry, complaint that you get. Another thing is communications with customers, and for purposes of this presentation, we'll assume that your customer is a potential employee or an applicant, because we'll switch to that after we go through a couple more slides. But have a process in place to handle complaints and inquiries. So not only do you want to make sure that you're complying with the law, but if you have issues that are raised, whether it be through another company, a potential employee, anyone, you just want to make sure that you have a process to handle those complaints. It's not getting sent to an email address, help@abccorporation.com, and nobody is checking that email address and they just sit there. Or if you tell someone you're going to call them back. This is basic customer service, but don't let customer complaints or inquiries go unanswered. We see this is a lot of times, especially when we're dealing with private causes of action, which would include class action complaints. A lot of times this is where we see these things get the start. There's a handful of customers who have called, they're unsatisfied, they're not getting responses to their questions, they turn to the BBB, they turn to their state attorney general, they file complaints on consumerfraud.com, and all of this comprehensively is what can sometimes get companies into trouble. So if you try to keep your customers happy, or at a very minimum communicate with them, it puts you a step ahead of a lot of companies. Okay, so now I want to turn to FCRA compliance and kind of the meat of this presentation, and that is how employers can comply and what implications FCRA has on the hiring process. So a lot of people don't realize, but if you are running a background check on a potential employee and applicant, that is considered a credit report under FCRA. And FCRA allows for job applicants to sue employers who fail to comply with any requirement imposed by the law. So as we'll go through here shortly, there are requirements for, before you run the background check, after you get the background check, and if you ultimately determine that you are going to take some sort of adverse action against that applicant, then there are requirements for that as well. So, particularly if you are a company that solicits a large number of applicants, you want to pay special attention to this, just because that large applicant pool, depending on the FCRA violation that may or may not exist, that could subject you to class action liability. So for instance, I'm thinking if you are a retailer and you do some sort of mass employment drive, or try to solicit a bunch of employees for holidays, and they come to find out that there has been a FCRA violation, and you've now that violation has applied to 1,000 interviewees. That's very, very, depending on the facts, that's a very appropriate number of plaintiffs for a class action. So, just in general, FCRA safeguards job applicants by ensuring that they have the right to be informed of the background check. So that's kind of step one. They have to provide consent for the employment background check. They have the right to review information pertaining to their personal and financial information. They have the right to correct any inaccuracies that may show up in their background check after it comes back. And then also, they have the right to appeal any decisions that are made that they feel that were made unfairly based on that background check. So as I mentioned, there are kind of, if you want to think of it as different stages of compliance that an employer needs to comply with. The first is disclosure and pre-authorization. And again, that's just disclosing to the potential employee that you are intending to run a background check and getting their consent to do so. And then next, depending on what comes back, whether it be a court filing that showed up or some sort of financial information that, just doesn't seem right. If you're contemplating some sort of adverse action, the applicant is entitled to a pre-adverse action letter, a copy of the report, and then notice of their rights under FCRA. So basically what that would be is a note sent to the applicant stating, we found this on your report, we are giving you the opportunity to respond to this. Here are your rights under FCRA. And, we will give you a certain amount of time to respond to this before we make our decision. The statute does not prescribe a specific amount of time, but generally 30 days is considered a good waiting period. And then after that period has passed and the applicant has had the opportunity to respond to anything that may have come up on their report, the employer has the opportunity to, make their determination of whether they want to move forward with this applicant or not. If they decide to take any sort of adverse action, i.e. not employing the applicant or discontinuing the employment process, they must send the applicant an adverse action letter. And, again, the FTC puts out a bunch of resources, and it gives sample letters, and so you can do that verbally, electronically, or in a writing to the applicant. And basically this letter just explains the individual's right to review the information, and then they again have their opportunity to appeal that. In terms of other considerations, one thing that I think is important is in terms of equal opportunity employment, you want to make sure that you don't have your background policies and procedures set up such that you are excluding certain groups of people summarily if something comes back on their report, or if you have it documented as to why you do that and how it's applicable to your business and why it's important. So just as you're deciding whether to move forward with an applicant or take some sort of adverse action, I would just consider those things. And again, if you have any questions or, are kind of thinking of, is this type of group okay to exclude, or do we need to do it a certain way? I would encourage you to reach out to your counsel. I think we're all in kind of living in a time where, there's a lot of attention to, different groups of people and that sort of thing. So you just want to make sure, A, that you are doing the right thing, and B, that legally it's documented correctly and that you are keeping your business compliant. So that's kind of the what do we need to do? And then now I want to turn to, well, what happens if we don't comply? And we've mentioned a couple times class actions, and I think that is that's a big one for sure. But also you have to consider the reputation of your company, how it can impact the perception, and depending on what sort of organization you are, what the community thinks, engagement, your vendors, that sort of thing. But other than all of that stuff, you've got the financial penalties, and even if you settle, it's still a lot of money, it's a lot of time. These sorts of lawsuits, and any lawsuit for that matter, they're not quick. They can take months or even years to resolve, and that's months or years of your employees working on, whether it's responding to discovery requests or having meetings with your outside counsel. That's time that they are doing that stuff instead of their job duties that they were hired for, that could take your company to the next level. As we talked about earlier, FCRA lawsuits have steadily increased over each year. So, it's definitely something that's under the spotlight and something that deserves some attention. So there at the bottom, I have kind of just a summary of some of the most common FCRA violations. So, failing to give disclosures, failing to gain consent, and improper adverse action procedures, failure to share results with the adverse action notice, and then failure to provide a summary of rights. So these are all things that we have talked about. They are all things, if you can build them into your policies and procedures, and you are doing some sort of frequent auditing as to whether those policies and procedures are being followed, are notices going out correctly, are the proper timelines being followed, are we responding to complaints? This stuff is, I don't want to say it's easy to comply with, but it's not complicated issues. I know everyone's busy, everyone's got a lot of things going on. So, in that sense, it is hard. It's very nuanced, but if I would just encourage everyone to build these sorts of things into your policies and procedures, revisit it every now and then do some sort of auditing to make sure that you are in fact complying with the requirements. So again, during the hiring process specifically, how do we comply? Again, I would encourage you to consult with your legal counsel, not only implement those policies and procedures, but audit against them. If you are, as you go to get your background checks, make sure you have good contracts with your vendors, and that you're using reputable screening services. I always encourage clients, if you are engaging a vendor, put an RFP and, look at 3 different vendors and see what their level of service is and how they can help you. And then once you've selected, again, take the time to engage in a very comprehensive service agreement with them. Make sure you're reading through the agreement. If you need to, consult with your legal counsel to help you read through those agreements to make sure the appropriate provisions are in those. And then also, there's certain state-specific laws that you need to take into consideration depending on where you are or where your applicants are. And I just have two examples there, California and Massachusetts, and they have regulations in place that specify that an employer cannot consider or seek information about arrests that did not involve a conviction when they are making determinations on hiring and, you know, whether or not to take adverse action on an applicant in the hiring process. So, you know, there's a handful of states that have certain regulations like that that are just kind of one-offs. And I would say that your vendor, your screening service that you are using should be aware of those. But again, it's always good to check with your counsel, make sure those sorts of things are covered in your vendor agreements, and then you should be good. So that is all I've got for today. I want to thank you all for attending. I have my email address and phone number there on the screen. If anyone has any questions, we don't have the live question available due to the short nature of the presentation, but if you want to email me a question or enter it into that chat feature on the right, I am more than happy to take those and address them as I get them. So again, I appreciate everyone's time and hope you all have a very good day.